My name is Mike Foster, and we're back here. We have just gone through data gathering. And what I'm going to do now is I'm going to talk to you about what we do with the data once we've gathered it. And I want to go through with you and show you some of the techniques that can be employed in large estate planning to try to reduce or eliminate federal estate taxes. Just to review with you some of the material we looked at in the earlier video, we set up two estates. We set up a large estate for a father and a mother. They're hypothetical cases. And we came up with data on the slide worth $8,750,000. And then we also did data collection for a son and his wife, and he participates in the father's business, and his estate is about $735,000. And we've got slides up showing you the respective inventories of assets that were collected from the data gathering process. And when we take those, we also set out in that session the goals and objectives of each particular client. And we said our primary goal is to be sure that we leave as much of the assets of the estate holder to the people they choose to leave it to with as little loss to outside parties as possible. If we take the estate, the large estate, the $8,750,000 estate, and we run it through the numbers and assume that the estate holder has no planning in place whatsoever, what we will see is that if the individual dies intestate, that is, they die without any will or any kind of testamentary document in place, the assets are going to be transferred by the laws of intestate distribution. And the result, if we flip to the slide with the flow chart, the red boxes illustrate what the IRS is going to get out of that in the form of federal estate taxes. And we can see that those taxes are going to be a little over $4 million on that estate, and the total cost of the estate is going to be probably closer to $5 million. And that represents nearly a $55% reduction in the value of the estate. We can do better than that. We can improve on that. And then what I want to do is illustrate that next to some of the problems with intestate succession. In addition to the fact that there's a lot of taxes that are involved in intestate succession, the formulas for how much each heir gets are dictated by statute. And what happens when a person dies without any kind of testamentary document is this entire inventory of assets has a title on it. It has the estate holder's name on it. So to change that name to the successive heirs, we have to go to a court and petition them to change the name on the title. That's called a probate process. And we'll describe that. We'll get into more detail on the probate process in the videos dealing with living trusts and overcoming probate and ways to avoid probate. In this particular session, we want to point out that with intestacy, the judge is given a set of formulas for how to distribute this particular estate in the statutes that the particular state has written. Most of those formulas for intestate succession have been inherited by the 50 states of the Union. They came over on the boat when the United States was settled, and they've been pretty much embedded in U.S. law. And the judge has to follow those directions and those formulas regardless of whether it was the actual intentions that we knew of the estate holder or the estate holder's spouse when they died. The other problem, so those are imposed on the estate regardless of the impact. The spouse is only going to get a portion of the estate if the individual dies intestate. In Florida, that would be a third. In other states, it could be as much as a half, but she doesn't necessarily get the whole thing. In addition, the heirs who are involved in the family business will lose control of that family business because it's going to be disseminated equally amongst the other shareholders, and they'll be a minority shareholder, so they won't necessarily be able to control the business. And of course, that could severely impact the profitability of the business. If any of those individuals were to pass away, the in-laws could become heirs to the business. In the estate plan of the son, if he owns a piece of the business, it's important to the parents that that son leaves his share for the grandchildren. They may not necessarily want that share to go to an in-law who survives, because that person could easily go on to marry someone else, and we have a whole package of problems that can come with that situation. In addition, if we have disabled heirs, they're going to lose their assistance. If they're on state and federal assistance, they'll be immediately disqualified from that assistance until their inheritance is spent down. Then they have to go through the process of requalifying. So they not only have the emotional problems of dealing with the disability, but they're going to have heaped on top of it some severe financial problems. If in our scenario, in our data gathering, we had one of the heirs addicted to chemical substances, and they will now have complete access to completely overindulge with their inheritance, much to their own detriment, possibly even to their death. And then there's the tax losses that are substantial. In this case, they were about 58% of the estate. The individual needs to put their plans down. They need to sit down with somebody and make some sort of documentation of what they want those particular, how they want these things distributed, and we need to deal with these particular anomalies in the family. And as he indicated in the data gathering, every family's got their anomalies in one way or another. Well, sitting down and writing a will is not the end all. Wills are great because the individual can dictate their own directions. They don't have to follow those formulas in the intestate statute, but will still go through the probate process. So we can deal with those unique family objectives as far as the nature of the heirs, the nature of the assets, the different family needs. But we need experienced advisors involved, and a will can still provide those specific directions. But as we can see here from the slide showing the flow, a simple will really doesn't help us a whole lot with the tax situation. In our flow chart, we still have red boxes with multi-million dollars going out to either the state government or to the federal government or to probate administration. And we have probably as much or more loss to the estate as we had dying intestate. Furthermore, we can't just divide the assets equally because it's going to, as I said, disqualify one heir. They need to have their assets held in a special trust if they're disabled. An heir who's got addiction problems is still going to have access to their funds. They're going to need some sort of way to hold those assets to support them without them having full access to the pile that's left behind to their own destruction. And then the people involved in different businesses have got to be able to run and control those businesses. If they can't, those businesses become unprofitable and they end up collapsing, and the family loses the family enterprise.